Assalamualaikum warahmatullahi wabarakatuh. Hi everyone. Today I'm gonna talk about the responsibility of state civil administrative concerning to unlawful act in exercising its authority. My name is Hanifa Arianto. Here we go. First of all, we are going to talk about what is the position of the state civil apparatus in the implementation of state administration based on Law Number 5 of 2014. And the second one is what are the responsibilities of the state civil administrative concerning unlawful action in exercising its authority. Let's talk about the position of the state civil apparatus in the implementation of state administration. Actually, the state civil apparatus is a profession for civil servants and government employees with a work agreement who work for government agencies. Civil servants of the state are appointed by civil servants and assigned to a government position or assigned to other state tasks and are paid based on statutory regulation. And when we are talking about the positions, of course, the state civil apparatus serves as an element of the state apparatus which implements the policies that set by the leadership of government agencies that are free from the influence and intervention of all political groups and parties, and it functions as a tool for public policy, public service, and unifying the nation. Also, the state civil apparatus acts as a planner or implementer and supervisor of the implementation of general government duties and national development through the implementation of policies and public service that are professional, free from political intervention, and free from corruption, collusion, and corruption practices, and also nepotism. In carrying out its role as public servants provided by the government to the community, a state civil apparatus is often used as an indicator of the success of the government administration system. Also, the national reform will be meaningless if the public services are still bad, especially in the context of realizing good governance in which accountability is one of the principles that must be put forward in the prime of the administration by the state civil apparatus, which cannot be delayed. So far, the level of public trust in the state civil apparatus tends to be negative, lazy, corrupt, loss-serving, unproductive, and so on. So it requires two reforms or changes to the mindset that is oriented towards community services. Based on Article 4, Paragraph 1 of the 1945 Constitution, it is stated that the President is the head of government. As a consequence of this, the President acts as the holder of the highest executive power. In the concept of low state administration, the President as the head of government has an impact that the President has the authority to regulate and administer in the frameworks of carrying out the governmental tasks or duties. Or in simple words, we can say that the President holds the highest power in a state civil apparatus policy, professional development, and management. And in carrying out these duties, the President is assisted by the ministers at the central government level and governors, regions and mayors at the regional government level, who is positioned as a government official under the President. However, it is clearly stated that the implementation of general government duties is carried out through the interconnected and continuous work system, which is referred to as a government bureaucracy, which is basically that the duties assigned to the government apparatus through the government bureaucracy that are carried out by the civil servant both that domiciled in the central government and in the regional government. Actually, the state civil apparatus, as an authorized official, has the authority to carry out activities to regulate and manage in order to organize government affairs. The authority to regulate means that it is given to an official who is authorized to form policies in the form of regulation or regulating or in the framework of implementing laws. Furthermore, the authority to manage means that it is given to an official other than the main high ranking official, like the first one is to the ministers or ministries, and the second one is to the head of institution. The third is the secretary general at the secretariat of the state institution and non-structural institutions, and the fourth is the governors in the provinces, and the last one is regent or mayor in regency or city. And now let us moving into the second point. It is about the responsibility of state civil administrative concerning unlawful act in exercising its authority. And when we are talking about the responsibility, actually in general, it is the benchmark to determine the unlawful nature of an administrative action by the state civil apparatus that are at least determined by two things. The first one is, has the state civil apparatus exercised its authority based on the prevailing laws and regulations? And the second one is, has the state civil apparatus implemented the general principle of good governance in exercising its authority? Regarding the existence of the general principle of good governance, it actually becomes an interesting thing to discuss whether the existence of this principle is actually just a legal principle or is it a positive legal norm because has been clearly mentioned in articles of several laws. And if this general principle of good governance is only a legal principle, then it should be its existence doesn't have strict sanctions based on legislation, doesn't it? Meanwhile, in reality, the violation of this general principle of good governance will result in a lawsuit against the law. On the other hand, the existence of the general principle of good governance is not clearly formulated with more detailed arrangement, even though it is clear the formulation with a certain measures as an obligation requires the existence of the sanction so that this can become a behavior or attitude of state administration. However, this creates a gap between the state administrations because even though it is only principle, it is clearly stated that a legal norm, but it is not regulated in more detailed provisions. So one of the examples is the application of the principle of transparency. The negligence of the state administrator in this regard is not expressly stated as having material impact on actions or decisions of the state administration. However, as we can see that the general principle of good governance became very flexible, which tends to also result in legal uncertainty, so that it can be said that the general principle of good governance is not feasible to be a measure of the existence of the limits of the propriety in the context of state administration. In fact, on the other hand, there is another public interest, as we call as the sake for development to provide welfare to the nation. If this condition always continues, the broader public interest will be divided by a group elites who abuse democracy for the sake of their group, so that at least the regime in power will not be able to have good conditions in the eyes of the public. In its development, The efforts to make the general principle of good governance more concrete have resulted in an initiative to make the Law Number 30 of 2004 concerning to the government administration, which essentially provided more protection to the public by minimizing the possibility of the abuse of the authority by regulating the administration of government administration, soft and then government administration procedures, legal requirements like the formal or material of the government administration decision, and then administrative efforts to government administration decision, and then also to the government administration responsibilities and sanctions administratively, and give authority to the state administrative court to resolve the dispute. However, we can conclude that before the existence of the state administrative court, basically there are three lines of completion procedures administrative disputes. Namely, the first one is objection procedure line, the second one is administrative appeals, and the last one is line of actions or against actions. And also based on the Article 1365 of the Civil Law, furthermore, after the enforcement of the State Administrative Court, the procedure path in point 1 and 2 above then becomes the root of administrative efforts and must be taken before a civil lawsuit is made against the state administration. If this is not done, the lawsuit should be declared unacceptable. And during its development, the act against the law or the unlawful acts by the state administration is known as maladministration, as stated in Article 1.3 of Law Number 37 of 2008 concerning to the Ombudsman of the Republic of Indonesia, which stated that maladministration is behavior or action against the law, exceeding authority, using authority for purposes other than those for which that authority is intended, including the negligence or neglect of legal obligations and the provision of public services carried out by the state or government administrators that cause material and or immaterial losses to the public and individuals. However, this broad definition has the potential to hinder the running of the government because many things can be reported as maladministrations. But the Ombudsman authority is not to judge, but to provide the recommendations. This potential is not very influential. But what will happen is only a summon of the state administration to follow up the public complaints about the action maladministration. This will be different when the civil judges adhere to the definition of maladministration in the Ombudsman law because the wills of the government will be hampered due to the potential for a lawsuit that could get even wilder because it stated that there are immaterial losses. The conclusion is, nowadays in the practice, the trend or tendency to sue the civil lawsuit is still more numerous than the settlement through the state administrative court, even in the scope of the public service. In the administration of the state according to its main duties and functions, it is case that administrators or state apparatus according to the Law Number 5 of 2014 on state civil apparatus is a public service. And also in the practice of national state life, the implementation of public services is very important for the progress of the development of governance in our country. It means that the state has the obligation to meet the needs of every citizen through a system of government that provides prompt public services in order to fulfill the basic needs and civil rights of every citizen to the public goods, public services, and administrative services. However, It is very unfortunate. Even though the Law Number 25 of 2009 concerning public services has clearly and firmly regulated the concept of public service system, which contain values, perceptions, and behavioral references for the organizers and implementers of the state civil apparatus. And the sanctions stipulated in this law for state civil apparatus are not light. For certain violations, organizers and implementers of public services can be dismissed as state civil apparatus. And also, there are many forms of sanctions regulated in the public service law, such as written warning, release from office, salary reduction, demotion, and so on. And finally, what we really hope is just to all of the civil state apparatus in all over our countries, Indonesia, which is the positions as the element of the state apparatus and the state servants, can truly devote themselves as a public servant by providing the best service to the community and not placing themselves as the leader who are served or taking advantage of their service duties. And the second one is it is appropriate for a state civil apparatus as a state servant to run their authority does not commit act against the law in order to be subject to disciplinary punishment because their actions have resulted in harm to others. Well, that's all my presentation. Thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh.